Hey everybody, it's Paul from Cary Estate Planning. I wanted to jump on and do a video today about guardianship in North Carolina. How does it work in light of the Free Britney movement with Britney Spears and the conservatorship in California? What does it look like? Why does it happen? What are some of the factors that drive towards or indicate guardianship is appropriate? And then how can you, as a private individual, prevent guardianship in the future by planning now? So first off, Britney Spears is under what's called a conservatorship, which is a form of legal relationship in California that speaks to the management of someone's financial and transactional affairs when they're incapable of managing them themselves, right? And so the issue with Britney Spears is that there were essentially allegations or some evidence or indications that she may be susceptible to undue influence, that she may lack the ability to sort of resist that influence, or that people were taking advantage of her. That in California is a basis for the creation of a conservatorship, which is basically a court deeming you incompetent for the purposes of conducting your own affairs and basically giving the rights to conduct your affairs to someone else. In this sense, it was basically her dad, Jamie. And so in North Carolina, the version that we have, or sort of the analogous legal proceeding, is what's called guardian of the estate. And the estate is essentially the property rights of an individual. And it could be their rights to transact, to conduct their own transactional affairs, which would include, signing contracts, selling or buying property and those sort of things. And then also the management and ownership of property itself. Could be financial assets like bank accounts or investment accounts. Could be real or personal property. Tangible property could be any number of different types of ownership or classes of assets. But essentially what happens is somebody applies to deem an individual incompetent for the purposes of conducting their own affairs. They have to submit and show credible evidence to that effect. In North Carolina, the court will assign what's called a guardian ad litem to basically be an independent party to assess the circumstances and give an opinion to the clerk of court as to the capacity or competency of the potential ward, or the person who's being petitioned against, and as to the qualifications and the appropriateness of the potential guardian, or the person who's applying to become the guardian. And the idea there is that the court is trying to find some objectivity, some unbiased opinion and evidence to inject into the determination, because essentially the clerk is seeing this for the first time, and he or she doesn't know anybody involved, not from a personal level, and so they have no independent knowledge or facts to base things from. They're basically receiving information given by the potential guardian, who may be biased, and then information given by the potential ward, who may also be biased, right? Their interests are generally adverse to each other. And so the guardian ad litem's opinion and report is not binding in any way. It's just a matter of injecting independent opinion and fact finding into the determination. If it's deemed that the potential ward is incapacitated, incompetent is what the legal standard is called. Incapacitated generally is a medical term. If they are deemed incompetent, then it's a judicial determination of competency and that it is lacking. And so if that is the case, then it's incumbent upon the court to appoint a guardian to basically manage the affairs and rights of the person who is now incompetent. And so with the Britney Spears matter, that ended up being quite involved because she does have so much wealth. She does have so much, accumulated over her lifetime. But then there were obviously the ongoing affairs that she continued to have, since the early 2000s. In North Carolina, the guardian is sort of kept in check by the court. And it seems to be the case in California as well, that any big transactions have to be approved ahead of time by the court. Any financial transactions generally have to be accounted for through an annual accounting. And then obviously in North Carolina, there's a requirement that the guardian be bonded in order to essentially ensure their actions from impropriety, right? It's basically saying that if they do the wrong thing and, lose the money or abscond with the money, run away with it, steal it, that the guardian's actions will not negatively impact the value of the guardianship estate. it would then be replaced by the, surety policy. In North Carolina, though, it's a little bit different as to what the standards for guardianship are versus what the standards in California are for conservatorship. And so generally, an incompetency hearing is basically trying to find factors or facts that indicate a lack of capacity due to mental illness, intellectual or developmental disability, epilepsy, cerebral palsy, autism, inebriation, senility, disease, injury, or any similar cause or condition. But it says very specifically that showing poor judgment or wastefulness is not necessarily enough to show that a person is incompetent. They may just be making bad decisions. And so in California, the real basis for conservatorship was a lack of ability to control her own spending, or the susceptibility for undue influence from like her boyfriend or manager or third parties. And so that was sufficient in California, likely not sufficient in North Carolina. And we've also seen over the years, probably since Brittany's conservatorship was created, this push towards a least restrictive means standard when it comes to creating guardianships and removing somebody's rights and giving them to somebody else. And so we see this in North Carolina courts that, for instance, if a disabled adult child does not have any assets, then the court will not grant general guardianship over that child because they don't have an estate to manage. So they may only appoint a guardian of the person to control or coordinate their care, custody, control, and medical decisions. So we have this shift, at least probably since Brittany's conservatorship was created, towards this least restrictive means standard. And so not to give guardianship unless it's absolutely necessary. And so that's generally what guardianship would look like in North Carolina, why it would be used and who it's appropriate for in relation to the conservatorship statutes in California. But there are things that you can potentially do to avoid guardianship in North Carolina while you have capacity, while you are competent. And that would be proactive planning. And so what that looks like is creating things called powers of attorney, which are essentially you voluntarily giving or extending your rights to named individuals who you trust and believe will do right by you in the event that you become incapacitated in the future. So it's you consenting to it now for use in the future if you do become incapacitated. So instead of needing a guardianship to be able to coordinate your affairs, you're giving authority proactively. Another tool within the powers of attorney themselves is the appointment of a guardian clauses in those two separate tools. In the financial power of attorney, there will be an indication that in the event that a guardianship is needed, you would prefer that the named agents under the financial power of attorney be named the guardian as well. And so you're trying to control who these important people may be for you. In the event that the financial power of attorney is just insufficient for a specific scope of authority or purpose, then guardianship may be needed above and beyond it. The same is true for healthcare powers of attorney. There's generally going to be a guardianship appointment clause saying that if a guardianship is needed, then the named agent under the healthcare power of attorney should have the ability to be that the court should appoint that person. And so we don't have as much risk in that, some random third party or somebody who you would not trust, family member or not, would not be appointed to be a guardian for you if that were to be needed. Another tool that can be used to take things out of a guardianship estate would be a revocable trust. So to the extent that you own assets in your own name and you become subject to a guardianship, then your guardian has control over those assets. If they're in your revocable trust, the guardian does not have control of those assets. The trustee, who you appointed willfully and intentionally, would have control over those assets during your incapacity. And so it's you keeping control on your team and keeping it outside of the scope of the court's authority, so that there's a lot less risk of misuse or unintended consequences, or someone who you wouldn't have wanted being appointed to coordinate your affairs. So first off, guardianship is at least at this point in time in North Carolina, something that should be only given when absolutely necessary. And you have the ability to shape it proactively through estate planning. And so if this is something that worries you, or because you saw the movie on Netflix, I Care a Lot, also about guardianship abuse and, you know, the downsides of a lack of planning, then you should be doing planning. If you have planning in place, you'd have it reviewed to make sure that it's still doing what you want it to. If you already have a trust, you should consider whether or not it's appropriate to fully fund the trust or leave things on beneficiary designations. But this is all intentional planning around what your objectives are. And so there isn't like a right way to plan, but planning proactively is going to be key to avoiding any sort of, you know, ramifications of guardianship and those sort of things. So this is Paul from Cary Estate Planning. If you have any questions, just let us know. Paul at CaryEstatePlanning.com or www.CaryEstatePlanning.com.